Section 9. Idem abolition of Star Chamber and other arbitrary courts. In Hilary term following, Walter Long, mentioned in note to the preceding section, had his case tried, on an information exhibited against him, in the Star Chamber. He was sentenced to stand committed to the prison of the Tower, there to remain during His Majesty's pleasure, and to pay a fine of 2,000 marks to His Majesty's use, and further, to make his humble submission and acknowledgment of his offence, both in the Court of Star Chamber and to His Majesty, before his enlargement. Proceedings were bad in the same term, in the Court of King's Bench, against Sir John Eliot and others, on an information filed against them. The defendants refused to plead, and judgment was given against them upon an eildicit. It was to this effect: 1. That every of the defendants shall be imprisoned during the King's pleasure, Sir John Eliot to be imprisoned in the Tower of London, and the other defendants in other prisons. 2. That none of them shall be delivered out of prison until he gives security in this court for his good behaviour, and have made submission and acknowledgment of his offence. 3. Sir John Eliot, who offered the remonstrance mentioned in the preceding section, inasmuch as we think him the greatest offender and the ringleader, shall pay to the King a fine of £2,000, and Mr. Hollis, who drew the Speaker back to his chair, a fine of 1,000 marks, and Mr. Valentine, who assisted Mr. Hollis in the interesting scene in Parliament, because he is of less ability than the rest, shall pay a fine of £500. To all this the justices with one voice accorded. Some of these died in prison because they would not pay the fine, others, not able to pay it, on their petitions, submissions, and condition not to come nearer the court than 10 miles, and give a bond of £2,000 for their good behaviour, were released. This Parliament was dissolved, and it was not until 1640 that a new one was called. This was the Long Parliament, lasting from 1640 to the forcible dissolution thereof by Cromwell, in 1653. It was during this period, in 1640, that the memorable Statute of 16 Car. I. C. 10, was passed. This act regulated the Privy Council and dissolved the Star Chamber. It contained a clause providing that any person imprisoned by order of the abolished Star Chamber and other arbitrary courts, or by command or warrant of the King's Majesty in his own person, or by command or warrant of the Council Board, or of the Lords or others of His Majesty's Privy Council, should be entitled to a writ of habeas corpus from the Courts of King's Bench or Common Pleas, without delay upon any pretence whatsoever, that the officer having the prisoner in custody should produce him and certify the cause of his detention, and that the court before which the prisoner was produced should either reinland, bail, or deliver him within 3 court days after the writ's return. A violation of this section was punishable by treble damages. During this Parliament many of the Star Chamber proceedings were annihilated, and the House of Commons severely censured the Speaker of the late Parliament for his conduct. It further resolved that the proceedings had against the members for their speeches and conduct in Parliament were a breach of privilege, and that there had been a delay of justice in not bailing them in the Easter and Trinity terms mentioned, and that the securities for good behaviour, etc., demanded in the ensuing Michaelmas term, were without authority of law. To each of the sufferers, we are informed by Mr. Amos, in his English Constitution, page 175, £5,000 was awarded as a compensation for the unjust denial of that liberty which they had demanded, and to which they had been entitled by the writ of habeas corpus. 2.